This is the case of Norma Dizon Pamintuan versus People of the Philippines with GR number 111426 dated July 11, 1994. This case is under PD number 1612 or the anti-fencing law. Here are the facts of the case. A crime of robbery has been committed on February 12, 1988, which was reported by Teodoro Encarnacion to Parañaque Police Station of the Southern Police District and submitted a list and sketches of the jewelries robbed, among other things, from their residence located at Better Living Subdivision, Parañaque, Metro Manila. On February 24, 1988, three of these items or stolen items, a pair of earrings and a ring studded with diamonds worth 75,000 pesos, one set of earrings worth 15,000 pesos, and a chain with crucifix worth 3,000 pesos were displayed for sale at a stall tended by Norma Dizon Pamintuan in Florentino Torres Street, Santa Cruz, Manila. The public display of the articles for sale clearly manifested an intent to gain on the part of the petitioner. So the issue here is whether or not Norma Pamintuan was guilty of violation of the anti-fencing law or PD number 1612. The Supreme Court ruled yes, Pamintuan is guilty for violation of Presidential Decree number 1612 beyond reasonable doubt. Fencing, as defined in Section 2 of PD number 1612, is the act of any person who, with intent to gain for himself or for another, shall buy, receive, possess, keep, acquire, conceal, sell or dispose of, or shall buy and sell, or in any manner deal in any article, item, object, or anything of value which he knows or should be known to him to have been derived from the proceeds of the crime of robbery or theft. The elements of the crime of fencing are: a crime of robbery or theft has been committed, the accused, who is not a principal or accomplice in the commission of the crime of robbery or theft, buys, receives, possesses, keeps, acquires, conceals, sells or disposes, or buys and sells, or in any manner deals in any article, item, object, or anything of value which has been derived from the proceeds of the said crime. The accused knows or should have known that the said article, item, object, or anything of value has been derived from the proceeds of the crime of robbery or theft, and that there is on the part of the accused the intent to gain for himself or for another. In the instant case, there is no doubt that the first, second, and fourth elements were duly established, but whether the prosecution proved the existence of the third element, that the accused knew or should have known that the items recovered from her were the proceeds of the crime of robbery or theft, must be resolved. One is deemed know a particular fact if he has the cognizance, consciousness or awareness thereof, or is aware of the existence of something, or has the acquaintance with facts, or if he has something within the mind's grasp with certitude and clarity. When knowledge of the existence of a particular fact is an element of an offense, such knowledge is established if a person is aware of a high probability of its existence, unless he actually believes that it does not exist. On the other hand, the words should know denote the fact that a person of reasonable prudence and intelligence would ascertain the fact in performance of his duty to another or would govern his conduct upon assumption that such fact exists. Knowledge refers to a mental state of awareness about a fact. Since the court cannot penetrate the mind of an accused and state with certainty what is contained therein, it must determine such knowledge with care from the overt acts of that person, and given two equally plausible states of cognition or mental awareness, the court should choose the one which sustains the constitutional presumption of innocence. Since Section 5 of PD number 1612 expressly provides that mere possession of good, article, item, object, or anything of value which has been the subject of robbery or thievery shall be prima facie evidence of fencing, it follows that the petitioner is presumed to have knowledge of the fact that the items found in her possession were the proceeds of robbery or theft. The presumption is reasonable, for no other natural or logical inference can arise from the established fact of her possession of the proceeds of the crime of robbery or theft. This presumption does not offend the presumption of innocence enshrined in the fundamental law. The petitioner was unable to rebut the presumption under PD number 1612. Therefore, the guilt of the accused for violation of Presidential Decree number 1612 was proven beyond reasonable doubt.